Good evening, all people present and people not present here. Today is the 19th of July 2023 at 6:30 at the City Hall of Westminster. We would like to have a convened Planning Commission meeting. And I, Tony Bui, is the chair of the Planning Commission, would like to call the meeting to order.
Chair, would you like me to do roll call?
Yes, please.
Okay, Commissioner Anderson,
Here.
Chair Bowie,
Yes.
Vice Chair Hamadi is absent, Commissioner Power,
Here.
and Commissioner Walbert.
Here.
Okay, 4 commissioners are present with Commissioner Hamadi absent.
Now we will start to salute the flag. I would like to ask Jim
Sure.
Power
Be happy
to help with salute the flag.
Please place your right hand over your heart. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one
One
nation,
nation,
under God, indivisible, with liberty and justice for all.
Thank you. Now I would like to have a report from the Planning Secretary on late communication items.
Yes, thank you, Chair Bowie. We don't have any late communications tonight.
Okay, thank you. Next, do we have ex parte communications? Please present it.
Chair Bowie, since there's no items, site visit items, there may not be any ex parte communications this evening. I don't see anyone responding, so I believe there's none.
And the next item is special presentation. I saw it none. Is it right?
That is correct. There are no special presentations this evening.
Now we are open for oral communications.
Chair Bowie, would you like me to read the instructions into the record?
Yes.
Okay. This is the time of the meeting that members of the public may address the Planning Commission on matters of public interest which pertain to the city and are within the subject matter jurisdiction of the Planning Commission. Members of the public wishing to address public hearing items shall do so at the time of the public hearing unless extended by a majority vote of the Planning Commission. Comments shall be limited to 3 minutes per speaker. To address the Planning Commission, please complete a blue request to speak form that is provided at the entrance of the council chambers and submit the form to the Planning Commission clerk. When your name is called, please step to the podium and at that time state your name and city of residence for the record, which is optional. I have a speaker card here for Ms. Terry Rains.
Hello. FYI, Vice Mayor Nam Kwan Nguyen ordered a City Council review of your case 2022-370, a CUP to establish a PACE-affiliated elderly day healthcare center at 8291 Westminster Boulevard, which you approved 5-0 on May 3rd. There's absolutely no legally allowable reason to reverse this commission's decision on that case. This is government overreach. His stated reason, quote, the proposed project, a PACE facility with exclusive on-site medical treatments for only enrolled seniors, should be further vetted as it will generate more vehicle traffic to this already busy transportation corridor, unquote. What a stretch from reality that is. There won't be any more vehicle traffic from this use other than the vans that will deliver and pick up the seniors at staggered times and a maximum of 20 employees per shift, many of whom may carpool or take public transportation to and from work. 3 or 4 vans driving to and from the facility at one time is certainly not going to increase traffic on congestion on Westminster Boulevard. A traffic impact assessment and parking analysis was already done by K2 Traffic Engineering and submitted to the city on the behalf of the applicants. PACE is a wonderful program that provides comprehensive medical and social services to frail elderly people, helping them avoid going into nursing homes and saving the state up to $19 million per year. Vice Mayor Nguyen wants to reverse this decision to further his political support by doing a solid for his masters. Chair Bowie and Vice Chair Hamad, not here, some comments you made about this case at the May 3rd meeting were troubling. Facts, there won't be any visitors to the center. You cannot put surveillance cameras inside patient areas. Ever hear of HIPAA? And all patient loading and unloading will be done near the rear of the site. The applicant did agree to 2 additional conditions. 1, adding concrete curbing to all existing landscaped areas, and 2, adding exterior surveillance cameras to the facility. I spoke with the applicants at length during the July 12th City Council meeting. Their review public hearing was noticed for that date. They waited over 4 hours only to be told after 10 p.m. that their hearing would be pushed to the next City Council meeting. If the City Council overturns your decision, it could very well lead to costly litigation. Finally, staff, why hasn't case 2022-381 come before this commission yet? The Asian Garden Mall tenant was first told their hearing would be April 19th, then they were told there were higher priority cases, so they were bumped to May 17th, only to be told again there were higher priority cases, so they were bumped again to July 5th. But then the July 5th meeting was canceled due to anticipated lack of business. Really? Because theirs is business. And it's not on this agenda either. Maybe August? The city can't keep jacking these applicants around like this, because you wonder why developers and businesses are hesitant to come to our city. So please do better. I'm sorry that Vice Chair Hamadi is not present to hear these comments. I was told that you guys were not officially notified anytime there's an appeal or a review of one of your decisions. So consider me your formal notification. Thank you.
Thank you.
Chair Bowie, I have no other speakers.
First of all, may I ask a copy of the presentation by Ms. Terry Raines?
You can ask, but that is a public document that she didn't provide to you. So she can probably provide it after the meeting, and we can, if she wishes, because it's her prerogative, and we can provide that to you after. Otherwise, your record would be the minutes or the video.
Okay, thank you. If possible, please provide us a copy of your presentation, because in that there was something related to me.
And I don't have enough copies with me, sorry. So we'll do it after the fact. I can email it to you. I don't care, but it'll be after the fact. Thank you.
So Ms. Raines has indicated she'll send a copy to me, and then I can forward it to you. Okay?
Thank you very much.
Maybe.
Now we come to item number 7, approval of minutes on May 3rd, 2023.
I'd move approval.
So Commissioner Anderson has moved to approve. I just need someone to second.
I second.
Okay, thank you, Commissioner Walbert. And we'll do a roll call vote. Commissioner Anderson,
Yes.
Chair Bowie,
Yes.
Commissioner Power,
Since I was absent, I'm going to abstain.
okay, and Commissioner Walbert.
Yes.
Okay, thank you. That's 301 to approve those minutes.
Well, let me ask a point of clarification. That was the last meeting, correct?
Yeah, the minutes show we were all here.
Oh.
That was actually May 3rd, yes. May 17 is still pending.
Oh, okay, yeah. Hey, look at that. Thank you, Terry. Then I'd like to change my vote to an aye if I still can. Although I think it becomes
City
an aye
Attorney
anyways.
is
since the majority
shaking
vote.
his head in an affirmative, so we will change that vote to a 4-0.
Thank you, I appreciate that. And thank you, Terry.
Now we move to item number 8, public hearings. None, is that right?
That is correct. There are no public hearings advertised for this evening's meeting.
Okay. And number 9, regular business.
There are no regular business items to come before you this evening as well.
Yes. Number 10, do we have any reports?
Yes, actually, on the agenda, you'll see item 10.1 is the agendized update on state housing legislation.
Hey, good evening, Chair Bowie, members of the Planning Commission. We could switch over to PowerPoint mode. Appreciate that. Okay. Well, thank you for joining us tonight. As indicated in the agenda, we have a very brief presentation to share with you. talk a little bit about some of the more recent legislation that pertains to housing development. And I'm going to jump right into the presentation. Really, the objectives of this update are twofold. One is to keep the commission abreast of laws that pertain to the development process, in this case, housing. And then the other is to help foster a greater understanding of how development is processed, not only in the state of California, but here in the city of Westminster. And then by extension, the role that the Planning Commission plays in that development process. I will say that some of the things that we're going to talk about, particularly the first part of this presentation, is stuff that some of you were able to see recently at the League of Cities Planning Commission forum that occurred a number of months ago. So you may remember some of this, and some of this is new information. So we're hoping we can build on it. If we can think about this housing legislation as far as a theme, kind of what direction it's going in, I think the way you can summarize it is to say it's all about less local control and more by right housing. I think some of us know, if you've reading articles, there's a housing shortage in California, and according to the state, we are about 3.5 million housing units short of what's needed, according to Sacramento. So a lot of the recent legislation that's been passed by the legislature and signed by the governor is intended to specifically address this shortage by taking away local control that cities used to have and is now allowed by right with oversight from the state. So that's the general theme that we'll be talking about tonight. So with that, I'll talk a little about the laws that I'm going to discuss. And by the way, this is just really the first presentation of what likely will be many down the road. But tonight we'll focus on three things. One is the Housing Crisis Act, also known as SB 330. We'll talk a little bit about two more recent bills that took effect a couple of weeks ago. One is AB 2011, and the other is SB 6. So, and as I said, there's other housing bills we'll discuss at future meetings. Those will be presented as we develop more information on those bills. So the Housing Crisis Act, what is that? This is Senate Bill 330. It was chartered and adopted and became effective in 2020. It technically adopted in 2019. Generally speaking, it hasn't been utilized very much, and that's simply because a lot of development simply stopped during COVID. We did learn a few things about SB 330 and talking to other cities that are around us. We all collectively in Orange County, I think, are a little bit more educated about SB 330 than we were, say, in January 2020. SB 330 amends the California Government Code. It deals with specific sections involving section 65,905 and some other sections, 66,300. This is where the bulk of land use regulations are in the state code. The California Government Code is a part of state law. We also have like a health and safety code and so forth, public resources code, but California Government Code, particularly 65,000, is where everything from zoning codes, general plans, that all exist in that part of the state law. So as I indicated, really what these laws do, what SB 330 does, is it takes away a lot of the local control that we used to have. And, you know, I know Commissioner Anderson, who's been on the commission for a while, could probably tell you that there was a time a few years ago when if say a small housing project, if the staff was uncomfortable with the design, we could take that to the Planning Commission, and the Planning Commission could act as a reviewing body to determine consistency with the local design standards and also the zoning code. For example, if you felt that the building materials were not appropriate, the Planning Commission could approve or deny the project, or condition it to have particular materials. We can't do that anymore. That's the point of SB 330. The main point is that if it complies with the objective standards, it really needs to be approved. And it takes away the discretionary review that a planning commission used to have. So that leads us into the next slide. What's the difference between ministerial review and discretionary review? So ministerial review is really a more objective look at something. In many cases, the staff is saying, does it meet the setbacks? Does it have enough parking? Does it comply with the height limit? All these objective standards. If it does, generally speaking, it's going to be approved at the ministerial, meaning almost always the staff level. Discretionary review is where a body such as the Planning Commission or the City Council can use their discretion to determine if it's appropriate. SB 330 really takes away that discretionary review when it comes to housing. On other issues like commercial use, assembly uses like churches, synagogues, temples, industrial use, you have full discretionary review. But when it comes to housing, not anymore. So one thing about SB 330 is it means projects are still subject to the California Environmental Quality Act. So for example, a project could possibly meet all of our development standards, but perhaps still require an EIR, or a mitigated negative declaration. So it's still subject to the environmental review that's established in CEQA, the California Environmental Quality Act. The other thing about SB 330 is kind of what it applies to. There's essentially three categories. The first is all residential, period. It also applies to mixed use, where at least 2/3 of the square footage of a project is devoted to residential. And then, of course, the last one, which is a little bit redundant to the first one, includes all transitional and supportive housing. So all these three categories are then subject to SB 330. And SB 330 also addresses what the state law refers to as protected units. This is really important because when SB 330 was crafted, they were trying to meet two goals. There were some in the legislature that wanted to find ways to force cities to expedite the planning process for housing. And you can see that based on what I've just discussed. But there were other people in the legislature, and as a compromise said, well, we understand that this law is going to help move projects along, but we also don't want to displace people who are living in situations where they're low income and they might be gentrified by new development of SB 330. So SB 330 includes language that protects certain rental units. And that's what I'm going to talk about now. What are those rental units that are under the protected units category? So the units that fall into that category basically include four things. One is units that are protected by rent stabilization. We don't have any of those in Westminster, but in other cities, there may be projects that are, there's some kind of rent control. So if a developer came in and tried to do something with that particular property, those units would be protected. If the project already is a low-income housing development, it's automatically protected by other laws, but SB 330 adds to that and says, hey, wait, this is in the protected units category. You can't take out an existing affordable housing project and replace it with completely market rate projects without dealing with these protected units. And I'll talk about how SB 330 deals with protected units in just a moment. The third category are projects under what's called the Ellis Act. The Ellis Act is a law that was enacted years ago that applies to situations where a property owner informs the tenants of a project, I plan to get out of the rental business, so I'm phasing all of my renters out. If that has happened within the last 10 years and the tenants haven't left the property, they're also protected. And then the fourth criteria, which really applies to Westminster, is simply the existence of low and very low households occupying residential units. So for example, if you have a rental unit, regardless of what the rent is, regardless of what rent you charge your tenant, if their household income meets the definition of low or very low income, they are automatically considered a protected unit. So where does that take us then, as far as a protected unit? Well, so SB 330 provides the following protections. And again, remember, these are for rental units. The first is that the tenant has the right to occupy the unit up until 6 months before construction. So if you have tenants that meet this definition, you can't tell them to leave until up to 6 months before construction. They also have right of refusal if you're converting to an ownership unit. So you have to give them that right. And then the other one, this is the one that really we see a lot of here in Westminster, is you have to provide replacement units for low-income households. And I'll explain in a second a scenario, so hopefully it'll make sense, so you'll understand how that works. I'm going to go to the next slide, and so replacement housing for low-income units. The way this works is basically when a project comes into the counter, one of the things we ask in a housing project, we ask in the application is, give us income data regarding your existing tenants or any tenants that have existed on the site within the past 5 years. This is a requirement of SB 330. Most developers will say, gee, I don't know. The tenants moved out 6 months ago. I'm the new property owner. I just bought the property. I want to develop it, which is honestly a very typical answer. What the state law says is that in that situation where the property owner developer can't provide rental income information, we are then required by SB 330 to require an equal number of low or very low income dwelling units based on the percentage of low income households in the city of Westminster. That's what the law says. So, as it turns out, based on federal data, about 80% of the rental population in Westminster meets the definition of low income. That's a very interesting fact. Below here, I give you the actual number for 2023. A household of 4 individuals earning less than $114,800 a year, by state standards, is considered low income. That probably includes a lot of teachers, police officers, other professionals, but they technically meet the definition of low income. So when a developer comes in and they realize that they want to tear down an existing house or a duplex and they can build 4 units, at some point they realize that they're going to have to set aside some of those units for these lower income occupants. And they have to set that aside for a period of 55 years. So the restrictions on the affordability exist for 55 years. This is the key part of SB 330 as it relates to getting replacement housing and not displacing current or past tenants who have occupied a residential property. Now, this is pretty important stuff, and we're dealing with this in the past 3 years. We have a number of projects in the pipeline, and there's some that have already been approved where they are required to provide this housing, this affordable housing, based on a percentage of how many housing units in their total project have to be set aside. So the next thing we'll talk about, if I go to the next slide, is AB 2011. The AB 2011 and SB 6, which I'll talk about momentarily, were actually approved last year, but they took effect July 1. So these are laws that have just taken effect. These are laws that allow for by right ministerial approval of multifamily residential on parcels zoned for commercial use. So for example, if the owners of the Westminster Center said we want to build housing, and they met the criteria of AB 2011, they would by right be allowed to do so. That's what AB 2011 says. Projects that meet the criteria of AB 2011 are exempt from CEQA, so there is no CEQA review. It's a simple notice of exemption. But at the same time, there are some stipulations. Well, actually, I wouldn't call this a stipulation, but one of the other requirements of AB 2011 is they're not required to provide any parking, with the exception of disabled parking. So theoretically, a developer could come in and say, I'm going to build 500 units, and I'm not going to provide any parking except for the disabled parking. I seriously doubt that would happen, simply because in order to rent a unit, developers understand they need to provide parking. But the point here is that they don't have to meet the city's parking regulations, and they can completely ignore them. They do have to meet the state requirements under the building code for disabled parking, and they would most likely provide the parking that they feel is sufficient. They are required, however, to provide affordability for some or all of the project, and they are also required to provide prevailing wages. And many developments here in the city don't use prevailing wages. That's often a way to say you're going to be using organized labor for your construction. And the other thing is, again, they have to provide at least some affordability to the project. So the next one, which is similar, is SB 6. SB 6 is called the Middle Class Housing Act. It's very similar to AB 2011. It also has stipulations as far as allowing for by right residential and commercial zones, and we have no discretion over that, neither the staff or the commission. However, some of the differences, these projects are not exempt from CEQA, so they potentially have to go through the CEQA process, which could be a mitigated negative declaration or even an EIR. Affordable housing is not required under SB 6, so they can do completely market rate housing, but they still don't have to provide any parking. That's a commonality with AB 2011. But they do have to provide not only prevailing wages, but they have to use skilled and trained workforce employees, which again is really just another way to say you'll be using union labor for the projects. I can tell you we haven't received any applications for either SB 6 or AB 2011, and we don't know if we will, simply because some of these requirements are relatively strenuous for most developers. But those are the three bills that we wanted to talk about tonight. In conclusion, I'd say there's just some basic takeaways for the Planning Commission as we continue this conversation in future meetings. Based on state laws, it is almost impossible to deny a housing project under SB 330 and all the other projects, including AB 2011 and also SB 6. You can see the trend is taking away local control over housing development. You will, as a planning commission, you will see, and you've already seen, fewer residential projects simply because of these laws and other laws where these projects are reviewed administratively and approved administratively by the staff. And then the other kind of key takeaway is over time, these laws are further reducing how cities can address parking. And that concludes the presentation. I'm available to answer any questions or comments.
Okay, so would you please have any question?
Yes, thank you, Chair Bowie. Yeah, Steve, has anybody or any organization, maybe some type of group, think tank group, done a study as to what the potential results of these recently adopted legislative actions will have on the state
Yeah.
and into the future?
I'm not aware of any studies, but I do know that there's a number of housing advocacy organizations who are suing cities who attempt not to comply with these things. There is a legal organization called Yes in My Backyard, and they've sent letters to a number of cities where they believe cities are not imposing these restrictions, and they're willing to take the cities to court. HCD has an enforcement unit. That's the California Department of Housing and Community Development has an enforcement unit, and they look for cities who are out of compliance with these regulations, not to mention ADU regulations, but these regulations. I think when these bills were proposed, I know the American Planning Association and the California League of Cities had issues with a lot of these regulations, that it's a kind of an overreach, but they've been adopted nonetheless. They were approved by the legislature, signed by the governor, and there's many more of these bills not only to come, but there's many more that we'll talk about in our future meetings. But the answer to that is, I think, I'm not aware of any studies that have shown the impacts, but at the same time, I think at this time, it's probably going to be irrelevant based on the direction that the governor, the legislature, and these other groups are pushing very hard to make sure that cities follow these requirements.
I know our neighbors in Huntington Beach and their council over there, they're fighting a lot of these regulations. From a lot of different perspectives, you can have residential properties being ruined, you can have residential and commercial properties being ruined.
Yeah.
Some developments are great, some aren't. Like you said, we haven't had any applications yet for a lot of these that would fall under these categories. But in general, when you've been talking with other cities nearby, what's the general consensus, or how are other commissions and other planning departments looking at this?
Yeah. I know in the Huntington Beach case, a couple of key differences. One, they do not have a certified housing element, and that is a big issue for them. Withholds state funding in a number of areas, so they're not eligible to get that funding. The others is that the Attorney General, the California Attorney General, Rob Bonta, is aggressively, I guess this is my phrase, is aggressively addressing Huntington Beach's noncompliance. And I think Huntington Beach is sort of the poster boy for what not to do. We've had this conversation with HCD staff. I know talking to other cities around us, Garden Grove, Fountain Valley, Seal Beach, they recognize that they don't want to go down the HB route. They don't want to end up on the wrong side of HCD for the same reason. At the end of the day, it's a choice, but And Russ, maybe, Russell, you might be able to also address this question about, what happens if we aren't in compliance with these regulations?
What was your question? Basically, the fact that if we comply with state law, we don't have to worry about, what was that, builder's remedy
Yeah.
situation, where any developer could come to town and just say, you don't have a certified housing element, so we're giving you this project, you have to approve it.
Yeah.
You basically take away all of the tools that the city has to say no.
Yeah, and that, thank you, Russ. So that's a good point, because there is another law that's referred to as the builder's remedy. And there are some cities, like Santa Monica, who got stuck with the builder's remedy. And those projects are essentially forced onto the cities, where you don't have a choice. You'll have to accept their density, you'll have to accept their design, and they essentially get to do what they want. Having a certified housing element, as we do, and I really thank the commission and council for working very hard to make that happen. We're in good graces with HCD. Nobody can come after us on the builder's remedy because of that. And also, as long as we're in compliance with our housing element, we really shouldn't worry about the state taking away funds from us. That includes highway funds, housing funds, and other monies that they could potentially take away if we were out of compliance.
One other quick question. Do you see or do you foresee any stagnation in development with older buildings because of the low income requirement?
Yeah.
That, developers want to come in and build something that they can obviously make money on. They want to be able to
Yeah.
generate profit from those buildings. And if they have to only charge well below market rates for
Yeah.
their inventory, it doesn't seem like we're going to get a lot of opportunities in Westminster to be able
Yeah.
to engage in those projects either.
Yeah, I do see that because I don't believe too many developers are going to take advantage of AB 2011 or SB 6 because of the affordable housing requirement. Most housing developers are market rate developers and they want to do market rate projects. So they're just going to find another way to do a project. Certainly the provisions of AB 2011 and SB 6 are very enticing, but the requirement for affordable housing and the requirement, based on the prevailing wages are probably two disincentives for a market rate developer. But at the same time, it is possible we could see a developer who says, I can make that work, but my guess is most likely not. But it also addresses another part of your question. I think we will see some sites that may remain vacant simply because of the market conditions. Despite these laws or any other laws, at the end of the day, the choice to build is a market decision of a property owner based on the right conditions and their ability to return a reasonable rate of return on what it is that they're trying to do. As long as that exists, it's really up to the private developer. So I agree that we may see things set idle for a while.
In the SB 330, you indicated about the transitional supportive housing. Can you explain about that clause?
Explain about the,
SB 330, transitional supportive housing.
supportive housing, yes.
Yeah.
So it's a very good question. Thank you, Chair Bowie. If we think about a type of housing that addresses two things, folks who are unhoused generally need one of two types of housing. They need what's called transitional housing, and as the name implies, transitional housing is not intended to be permanent housing. It's intended to be the type of housing where somebody's brought off the street, they're sort of reincorporated into society, they learn how to hold a job, they learn how to pay the rent, how to be responsible for themselves. And then at some point, they transition out of that into a more permanent situation. So transitional housing, you might have a tenant that's there for a year, maybe two at the most, who's learning to rebuild what they've lost when they became unhoused. And we do have transitional housing in the city. It could be for a shorter period of time. They may only need a month, 2 months, 3 months to make that transition, but that's what transitional housing does. Supportive housing, on the other hand, is a type of permanent housing that supports an individual. And again, these are often individuals who are unhoused. They might simply have been unhoused and they've had some mental health issues or other issues, substance abuse issues. But this is permanent housing for them, and they're permanently supported through programs. Those programs could be recovery programs. Those programs could be mental health programs, programs to make sure they get to their doctor appointments. A great example of a supportive housing project that's been very successful is the De La Rosa project on Beach Boulevard. You probably drive past it from time to time. It's a very attractive project, and people forget that that is permanent supportive housing. People are living in those units who, in previous times, have had serious issues with mental health or substance abuse, and many of them are now living there permanently, and they're off the street. The same thing with the project at the crossings. There is, some of the units are permanent supportive housing. We see this throughout the county. But that's really what those two types of housing are.
I see. And another thing is AB 2011.
Yes,
They said that no parking requirement.
that's
In that
correct.
case, how did we solve the problem for
Yeah.
parking overflow to the vicinity?
Well, that's the dilemma is, on the one hand, the state is saying no parking requirements. The reality is, I've never known a market rate developer who would ever even think about developing a project without parking, because you can't sell units and you can't lease units unless your tenants or your buyers have parking. So they will provide parking. It just may not be exactly what our code requires. So in a sense, what AB 2011 is saying, let the private market decide how much parking should be there. Because in reality, nobody's going to provide no parking. They will provide parking.
I see. Thank you.
That's the difference.
In regards to the parking issue, and not this legislation, but under the accessory dwelling unit legislation, if somebody puts an accessory dwelling unit in their backyard, are they required to provide any additional parking?
The quick answer is no, simply because there's a state law that talks about ADUs and their proximity to transit, like a bus stop. Virtually every residential parcel in the city meets that criteria in multifamily. So unfortunately, if you add an ADU to a property, you don't need to provide any parking. If you convert a garage or tear down a garage to build an ADU, you do not have to provide any parking. And the state is very, I would say, very direct about that. In fact, we had a conversation with a representative from HCD a number of weeks ago who reiterated a lot of these requirements in a discussion of our current ADU regulations. And by the way, we'll come back to the commission at a future time to talk more about ADUs. There will be some new ADU laws that the legislature will adopt and the governor will sign probably in September. When those laws come out and we have a little bit of time to look them over, we'll come back to the commission and do something like this, but we'll focus on accessory dwelling units. So the whole commission is aware of all those regulations as well. Yeah.
Thank you.
Do we have any more questions for Steve Radley? Okay.
Thank you very
Thank you.
much.
Now we would like to go over to matters from staff. Any of you have any things to bring up to the meeting, please?
Steve, it's matters from staff.
Yes, thank you, Trevor. I just wanted to thank the Planning Commission for all the hard work you do. It's nice to see everybody back here, and also wanted to thank the staff, Shelley and Russell in particular, for helping us put together tonight's agenda and making sure, and also the PCTA crew for helping us to run a smooth meeting. Thank you.
Okay, so do we have anything bring up to the staff, anything? No. So let's go to item number 12. Matters from the Planning Commission, including the AB 1234 report when required.
Nothing, Chair.
I just wanted to thank the staff for the very informative presentation. But other than that, nothing from me.
Okay. So, shall we come up to the item 13? We don't have any more things to discuss. Shall we make a adjournment now? And we'll be back on Wednesday, August 2nd at 6:30 p.m. Thank you very much for all of your attendance, and appreciate all of you participating here, and especially the video crew who work hardly in the background. Thank you very much.